would need to be researched, because family law has, as we know it today, is not the least bit similar to what we even knew in the 1960s. There's been an incredible revolution of assuming that the justice system across the world really had the right or the obligation to protect families by putting laws into place that establish rules for custody, parenting time, division of property, support, and things like that. And of course, for the laws on getting married itself. We have seen some interesting evolution in the last few years about how old you can be to get married. The age to be able to legally marry is actually going up as a trend, and that includes New Jersey and includes some international locations. Issues, of course, with same-sex marriage becoming legalized across the globe slowly are changing what you might be able to write about and how you might wish to portray your characters. But I think one of the most important points is that there's a lot out there for certain time frames. If you wanted to research the laws very specifically on what you could do for family law in the United States before the 1950s, the answer is probably that there might be very little out there for you. But if we're talking about more modern writing, then you probably do have the ability to dig into the archives of the legislative history of almost any state. So if your book is set in the Hudson Valley, that's one set of laws. If your book is set in California or Alaska, that's another set of laws. It's important to realize that family law varies a little bit from state to state, even if you're within the United States. So having touched on that geography issue and that time frame issue, are there any particular times or places that it would be more interesting to talk about than others?
I am a contemporary. I don't know about others, but my writing's all contemporary, and it's usually New York based.
Mine's the same way, though I've used different states. I haven't, it's still contemporary, but I've actually done a few single dad books. So, you know, anything you can add would be helpful with that. I've done one where the child is older. I've done one where there's an infant involved. So it kind of varies as far as custody and things like that.
So we'll definitely hit on custody. Tara, where are you writing from?
I'm also doing contemporary, but I was curious about like the types of restrictions that may be applied if the couple splits and moves to different states, like
Sure.
How, you know, how that would work.
Okay, definitely. Sounds like custody is something that would be interesting. Anybody else specifically want to aim me in a direction?
I would be interested in knowing what kinds of, if there are perceptions out there that people commonly get wrong. So, because, you know, there's certain things that people assume, and then it turns out that's actually not accurate. And so we do strive to be as accurate as possible. So screwing things up is definitely not what we want to do. And so if there are misperceptions that you commonly hear, that would be interesting to me to learn about.
Absolutely. There's a lot in custody in particular that I'll make sure to touch on.
Okay, great.
Anybody else? John? No? Okay. Or John, did you want to add something?
No, I was going to try to unmute to say I'm good at the moment, so sorry.
Okay. So let's talk about custody and parenting time then, and let's start with that. And so to deal with the issue in a contemporary context, one of the most common misconceptions at the moment is that the mom always gets custody. That is definitely not the case in the last few years. On the other hand, the other thing that is difficult right now that we are all struggling with, and I mean this literally in all 50 states and across the globe, we are struggling with whether it should be assumed that it is best for a child for the parents to have equal custody. So let's talk about what I mean by equal custody, because to the point about accuracy and striving to be accurate, I imagine that starts from the very first time you submit a manuscript, that an editor is not going to want you to stumble into something that he or she knows is an error, and then that could be a real downside for you in terms of getting your book picked up. So custody splits into two components, Amanda. Two. Custody splits into two components: legal custody and physical custody. Legal custody is decision making. It's called by different things in different states, but New York, New Jersey, Connecticut all tend to use that terminology of legal custody. And legal custody has to do with how parents make decisions for their children, who gets to make the final decision if there's a dispute, and what steps they have to take before a decision is considered to be finalized. And it is on limited topics. It is considered to be on those issues that are of such grave importance that it will have a long-term effect on the child. I'm not talking about day-to-day decisions like bedtime. I'm not talking about day-to-day decisions like whether a child gets this many hours of TV or screen time. I'm talking about what we consider the big ticket items. Medical decisions, elective and non-elective. Religious upbringing, which can always be interesting if you have a home that has a split or a dual religion. Education, which can have to do with run-of-the-mill issues, and choosing where the child goes to school, whether it's public or private. And then other things that tend to have long-term overriding effect. And there's a variety among families and what that can be. Some of our courts, like New York, does not go this specific, but New Jersey tells me specifically the choice of summer camp is a joint legal custody decision. It's just what some judge decided one day, and that has stuck. We're also in an era where I counsel my clients that joint legal custody needs to include a plan for how you are going to give your children digital access. And yeah, that when are they going to have a cell phone? What's the permissiveness going to be? Is it going to be a smartphone? Are they going to have online access? Are they allowed to play Fortnite? Are they allowed to do all these different things? And how are you as parents going to monitor it? I'm litigating a case on Tuesday where the primary issue is that my client bought the cell phone, pays for the cell phone plan, and told her 15-year-old son that she watches his Snapchat. He's not allowed to put protective on the phone to prevent her from seeing what he's doing. And the father was texting the child about the mother. We brought that into court, and the father has objected, saying the mother had no right to do that. I'm saying she did. She's the primary custodian. She has final decision-making authority. She bought the phone, etc. So these are issues that if you don't think them through ahead of time, they could be a great storyline. If parents have not dealt with them, this whole issue of children and technological access, to me, should be part of joint legal custody. When we get past joint legal custody and big decision making, actually, I suppose I should go back and talk a little bit about medical, because obviously anything having to do with a child's medical problem, the common thought is sort of two heads are better than one. And we often build in mechanisms where parents have the right to get second opinions. Of course, there's a financial component to medical decisions as well that has to be blended in a little bit. But ultimately, you want some way to make a decision, because the last thing you ever want a court to do, or a parent to have to do, is to look at their lawyer and say, what can I do? And for me to say that a judge is going to make that decision for you, it's just so wrong. It's so hideously wrong, the idea that a stranger would get to decide anything about my child's medical. And we are seeing in the popular press, so to speak, a run of case law, more internationally than domestically, on issues having to do with parents and medical decisions regarding a child's gender identity. There's a lot going on with that right now in terms of who gets to make those decisions. When does a child get to make their own decision? Because believe it or not, children are still children until they're 18. And the day they turn 18, some things change. I have an 18-year-old, so the fact that I can't sign in his own college medical information is just bizarre to me, that he has to do it by himself. But Tara.
I'm sorry. I just, when you were talking about the age of 18, I got like a strange email, like when my kids turned 12, that I no longer had access to their patient portal because they now turned 12 and I only had billing access. I don't know if you've ever heard that. I'm not the only one. Like New York Presbyterian actually sent that out. Like my access changed. So when you said that it was 18, I was just curious because I don't know. It was just very strange.
It was very clear that parents of children under the age of 18 have access to their medical records, and beyond that have the obligation to care for their children's medical records. If you wanted to take that kind of a question or an item in a different direction, Think about what Child Protective Services would do to a parent who said, I didn't know that the child had this problem. I wasn't allowed into their records.
Yeah.
I mean,
And
that
another
email is
parent had
bizarre.
I know, and another person had raised it one day, and I said, that is I actually had that as well, the same email. Like, honestly, it was just very strange.
It's strange. It doesn't sound correct. I can't imagine that they have the right to restrict parents from getting their children's medical records prior to the age of 18. But the day they turn 18, the schools are allowed to shut us down, and the doctors are supposed to shut us down. And what I did, especially right on the eve of this whole unfortunate coronavirus, was I had my 18-year-old sign a bunch of releases for me, so that in the event that I needed to do anything for him now during the crisis or not, I can get his medical records. I have, my husband and I have medical power of attorney over him, and we have full access to his educational records. But I wouldn't have thought of that if I weren't a lawyer.
Yeah.
It's not like the schools tell you that. And
a good idea.
It's an interesting dilemma, because although once children are 18, they get to make their own decisions in theory for medical and other things as well, they're still under their parents' roof most of the time. So we're going to come back to this idea of when children segue into adults. To me, there's this gray zone when kids might as well be adults from the way you look at them. I mean, anyone who sees my 18-year-old on the street is going to say that's a grown-up. I don't see it that way, and he certainly doesn't support himself. So we're going to talk about that too, because I think emancipation and getting the kids off the family payroll and this whole idea of the generation that's come back to their parents' homes, and especially now, who knows what's going to happen with the financial crisis, you may find yourselves with all kinds of ideas about how to work those plot lines and how to incorporate the idea of what a parent's obligation is to an adult. The short answer is none. You don't have to let your adult kid move back in with you. You don't have to support them. You have no obligation under the law to provide them with housing or anything else. So that's a quandary, I think, for a lot of parents. But going back to this issue of custody, and not to get too far away from the questions that were raised at the outset, we talked a little bit about this idea that there's this legal custody, and that covers things like medical, religion, education, camp, to me, internet access, and other things like that. And if anybody wants to talk about that more, we can certainly go deeper into it. But the other piece of it is physical custody, time sharing, or parental access is kind of the new term. And this is one of my favorite examples of the issue that I spoke about at the top of our talk, which is that over time, family law has evolved. If you're talking about visitation in the year 2020 in the Hudson Valley, if you're writing in the Hudson Valley and you use the term visitation, people who do family law will know you're out of date. That's not the term we use anymore. That term has evolved over time. It's a term that dates, obviously was very prevalent. If you saw Kramer versus Kramer, it was all about visitation. 1970s concept evolved in the 90s into parenting time. And we really are starting to talk more now about time sharing. And in Europe, all they talk about is the access schedule, parental access schedule. And I think part of it has to do with wanting to get away from the idea that time is a commodity that we trade, that we bargain with. Because the schedule that your kids live under can be anything. There are no rules. There are in different areas, and so this may come down very specifically if you're writing about Connecticut in particular, if you're in that or some other states have actually county by county, some of them have standard holiday schedules that the courts impose unless the parents pick up something else. But generally, parents can do almost anything they want in terms of a holiday and week-to-week schedule, a vacation schedule, a special event schedule that they really wish to do. There are no limits. A judge will not typically impose his or her viewpoint on the parents. In New York, you automatically have a lawyer appointed for the children if there's any significant dispute about parental access or legal custody. So that's another character to know about. You don't automatically get that in New Jersey. You usually get it in Connecticut too. Parents pay for that, so money is always an issue, and we could spend hours talking about the cost of all of these proceedings and how that limits people's resources and abilities to perhaps pursue what they think is best. But in a nutshell, you wind up in a judicial proceeding about parenting time with a judge, a lot of staff. Usually each parent has a lawyer. Hopefully each parent has a lawyer if it's for something as significant as a child's rights to have both parents actively involved in his or her life, a law guardian or a guardian ad litem, or both. They're different things in New Jersey, but generally somebody who is operating on behalf of the court to communicate directly with the child. And sometimes, in addition to all that, a psychologist or psychiatrist or other mental health professional who's doing some kind of an evaluation to talk about what's in the best interests of the child. So best interest of the child is that catchphrase that we all sort of have heard thrown around. What does it really mean? It doesn't really mean anything. What I think is a better way of phrasing it, and what some of our professionals lean on us to think about, is if you agree that ideally that the best interests of your child would be served by not having a child going between two households at all, and if you assume that it would be best for a child for these parents to figure out a way to not hate each other and to not get divorced, then what is the least detrimental alternative? If you can't have your dream, if I as a lawyer cannot wave a magic wand, and I will ask clients this all the time, if I could wave a magic wand, what would you want this to look like? And they never give me the answer of, oh, I'd want us to all be happy and living under one roof. By the time they get to me, that's not the dream anymore. By the time they get to me, the dream is, I just want her to go. How do I get her out of my house? I have a client who sends me that email once a week. And I've told them it's okay. You can send me that email once a week. Don't send it to her because it's not your house. We'll talk about property. But the idea is that I want to be able to look at what kind of a parenting arrangement makes sense for every individual family. So the sky's the limit. You can do whatever you want in your storylines in terms of arranging it. And when people live in different areas, that's something else altogether. But let's stick for a minute with the idea of them living in more or less the same place, because part of the strain is usually the cost of two households and figuring out how to keep the kids in their community and how to figure out how to keep the kids entrenched or to get them entrenched in a new community. That's always a challenge for the parent who doesn't move to the new community. There is this idea out there, and Dawn and I spoke about this, so I wanted to make sure to mention it, of nesting, where the kids stay in one house and the parents move in and out. When resources allow the parents to have separate homes and move in and out of the children's homes, that might work. That might make for some fantastic fiction. What will make for some explosive fiction is if the parents are living in the same apartment and rotating in and out of the house. And so they're just going back and forth. They have no privacy. They have no personal space. What you've done is create two pressure cookers, not one. And I think it would be an extraordinary plot line to actually try to examine what it's like as a grown-up to never have a home of your own. To be so strong, to put your children first, to say that your children stay in the house and I will never, ever have privacy in my own home again. I will always share it with the ex, with the other parent. That could be rather an extraordinary thing to ask of a character, let alone a person in real life. To the issue of leaving the state or leaving the country. This is something that also has evolved over time. Obviously, everybody's got their horror stories. Everybody has read some headlines about children being abducted, about children being removed from their jurisdiction. By that, I mean by the state in which they live. And generally, the law is that you can't remove children from their home state, and I'll come back to that phrase in a minute, without a court order or consent of the other parent. Most states, New York, New Jersey, Connecticut, have that rule that you have to figure out a way to work out a custody arrangement for children that keeps them within the state borders. Now, living where we live, that sounds stupid, because I personally live in New York, I live in Rockland County, and I work in New Jersey. I cross the state line every day. Who cares? What's the difference? When it comes to children, there's a huge difference. And we don't allow it under state law and also international treaties and national uniform laws. So let me break those down. Every state has their own laws that can be really easily researched on the state websites, the state legislative websites, for what the current custody rules are. But in addition, most states have adopted the Uniform Child Custody Jurisdiction and Enforcement Act, the UCCJEA, and the Prevention of Parental Kidnapping Act. So these are what we call uniform laws. And this may be useful information to you kind of across the board in terms of researching anything if you're looking for some commonalities of law between different states. The Uniform Law Commission is a public website that lists all of the laws that have been adapted across the various states. And they'll give you a map of the United States, and they'll show you with different colors which states have enacted it and which haven't. And so it's been interesting to, as a family law attorney, to watch some laws spread. We've had some interesting new evidence rules spread and things like that that will enable us, for example, to take depositions across state lines. When I started practicing law, you couldn't do it. If I wanted to take a deposition of someone in Florida, I had to pick up and go there. There are new rules that have spread most recently to Florida that enable me to get evidence from across state lines. So that's something else for you to consider on this whole issue of when kids are moving around. If you need information from other states, the Uniform Law Commission and the Uniform Deposition and Discovery Act are the kinds of things that are going to make your characters really smart, or give them different kinds of resources for figuring out how to get information for the court that will be relevant to their kids. Because what the UCCJEA in particular, and what most state law tells us, is that you cannot remove a child from their home state. And I used that phrase before. And home state means where they've lived for 6 months. Sometimes there's some fussiness about that. Sometimes there's some wrinkles about that. For example, I brought an application in New Jersey at the end of February because my client had moved from Pennsylvania to New Jersey 6 months before. I went down in flames, couldn't get the judge to take the case because she was already in the middle of a divorce in Pennsylvania. So just because you move doesn't mean you stop a prior proceeding. And just because you move doesn't mean you're going to prevail and get to stay there. If you move a child within 6 months of, if you move a child out of their state, the other parent basically has 6 months as a matter of law, pretty black and white, to say, no, you need to bring this kid back to where we started because that's their home state. And the way you would typically do that is you turn around and you file for divorce or you file for custody in the original state. So, that's the kind of thing that makes for the drama, right? People racing to the courthouses, maybe the 6 months have elapsed, maybe there are no kids, maybe that's not the big issue in the case. But you see, particularly with families that have a lot of money, with celebrity divorces, I think Halle Berry and David Justice did this. One of them filed in New York and one of them filed in California, and they duked it out, and then they wind up, locking down in a conference room and settling it anyway. But the drama is there. Yes, Elizabeth? Unmute.
Yep. So is the 6 months, so for instance, June 1 to December 1? Or alternately, because the months vary a little bit with the days, is it literally like 180 days? I mean, because I feel like that could get a little technical element that could add some drama.
So it's going to depend how the different statutes are written. The UCCJEA is written for 6 months, but you would probably find that most judges would say that the difference between 180 and 183 days is not what we're really going for here. In that particular case that I was talking about, I absolutely waited 184 days before I filed. So no one could tell me the kids hadn't been here for 6 months, but I agree with you that, as with everything else, you can pick something apart like that. And the parallel action with that is the Prevention of Parental Kidnapping Act, which says that if you are the parent who picks up and takes the kids without telling the other where you're going, you can face some criminal federal charges as well. So that's always fun. Always fun when you get that call and the client tells you, I did this. I took a call right before all this started, that before the COVID-19 crisis started, she thought she'd pick up the kids from Hawaii and come to New Jersey. Her husband's active duty military, and he wouldn't know where she went. That's just not a good idea. That is not a good idea, dear. You're not going to do that. So trying to work out something else. Tara.
Does this matter whether the parents are married or not married? Is there like another layer of issues that one couple might face over another? Or
not anymore. But again, that's a timing issue. It is absolutely true that until the statutes, state by state, started to recognize that the children's rights to both parents is not dependent on the parent's marital status, that going back to the 60s and 70s, there is no question that there were some limitations on your ability to get custodial rights depending on whether you were married or unmarried, especially as an unmarried father, especially as a single dad, especially if you wanted to be the parent who was raising your kids. There were problems for a long time with the single dad who had the child abandoned with him. What rights did that father have, especially if he wasn't on the birth certificate? There are easy methods now. In fact, when we file now for custody and parenting time in New Jersey in a situation where the parents weren't married, it's a different court track. because there aren't all the same issues, but we have to declare parentage. As an affirmative matter, we have to declare parentage. And therefore, if the father in particular wants to say, look, it's not my kid, he gets the opportunity at the front end of any custody and parenting time and child support litigation, and has the opportunity to get a paternity test early on. We don't let that hit us at the back end.
So you mentioned birth certificates, and I've seen that used as a device in some stories, like the father's name is not listed on there, secret baby type of, or surprise baby type of thing. What is that realistic? Like, you don't put the father's name on the birth certificate, and then, how does he have no rights at that point, like you were saying, or?
So this is going to be technical in state by state regulations, but certainly when a child is born, if a child is born in a hospital, the mother has no obligation to list a father. They ask, but I did some work early in my career for Child Protective Services in Atlanta, Georgia. There were a lot of people who didn't know for sure who the father of their child was. And so it is not an obligation of the birthing mother to give the name of the father. The father has the right to have his name added to a birth certificate, at least in New Jersey, I'm sure of that. I've done one case where we were sufficiently concerned that the mother would not put the father on the birth certificate because they became estranged during the pregnancy, that we actually brought a action prior to the birth of the child for access to the hospital and for the name on the birth certificate, because the way that would have played out is if the mother had simply said, he's not the father, then he doesn't even get in to see the newborn. And that was what we were trying to avoid. So I'm not familiar enough with the technicalities state by state, but I'm sure that it's in the Department of Vital Records websites of all of the states you could ever want to put a character in when it comes to the birth certificate. And I'm sure there's a mechanism for adding a name to the birth certificate, because we change birth certificates for other reasons too. Dawn.
Yeah.
Two questions. One is, say you're married and the wife goes and takes the kids away without telling the father. How much time has to go by before he can start calling it kidnapping?
That is a great question. It's going to depend on the real question of, does he really not know where she is? And so it starts with missing persons and whether you can get local police authority interested in raising any criminal charges. There's a difference, I think, between, I'm not really sure where she is, but I haven't bothered to call her mother's house. And I honestly don't know. I've only been involved in one considerable international kidnapping case. It was, it's almost 20 years ago now, and the child is an adult and has never been returned. And the mother, my client, actually kidnapped the child to Spain. The Spanish authorities would not cooperate with returning the child to the United States despite court orders, and the mother went to jail rather than bring the child back. And ugly situation. So it's not about time, it's about proof. It's not about the amount of time that the children are missing. You've got interference with custody statutes that go to the court of the parent of the parent's rights, the one who's left behind, so to speak. But more on kidnapping, you've got the question of, was a child intentionally removed from the known home, and is it really not legitimate where they are? It's more about what happened than when it happened.
Okay, the other question is there anything to stop anybody from putting a man's name on a birth certificate, like Brad Pitt?
Nope.
Okay. No. You could work it into a plot somehow. So you want to meet Brad Pitt. You link it to
the other problem you have is that names are what names are, and none of our names are unique. We don't own them.
Yeah.
And I have seen a situation where someone was called into court for child support purposes, and it was just somebody by the same name.
Yeah.
So going back to the father, and their rights, like let's say the father is not listed, and they suspect that it's their child. How easy is it for them to just I guess request or demand a paternity test? Does the mom have to comply? How does that work?
It's very easy. I mean, the I don't recommend to people who come into my doors. I don't recommend home testing, even if you have access to the child. But in terms of the court system, it's a very straightforward application. People are capable of walking into family court in New York, New Jersey, Connecticut, and filing that themselves, basically saying, I want a hearing on paternity. It's really that straightforward. And, you know, the risk being, if you are the father of a child, then you are going to bring straight on yourself an application for child support. And that may be what you're looking for. That may be what you want. It's very rare. I've, only ever stormed into court once declaring I am the father and I want to pay child support, but it was a fun thing to do.
What about if, is it possible if a mother and father are known, they have the child, their birth certificate is generated, both mother and father are listed on it, and then things go horribly wrong and the father turns out to be a serial killer, and the mother would rather not have the child know who his real father is there a way that they can actually remove a name for a birth certificate, or is that like once that's set, it's set?
So if a parent's parental rights are terminated, that ends the legal relationship but doesn't terminate the identity. So what you're talking about there is trying to convince a court in an abuse and neglect case, child protective services case, that it is so detrimental to the child that the father's parental rights of access and parental obligations of support should be terminated, and that it is of sufficient psychological importance to change the birth certificate as well. I don't really ever see that happening, because then what you're doing is depriving a child of a right to, or potentially of a right to know who his or her parents are. I think it could be an interesting application to a court. I'm not aware that it's ever been done. The more prevalent line of argument would be that there's a step parent ready to come in, or another parent who's willing to come in and do an adoption, and that you want a new birth certificate issued for the adoption purposes that names the new parent. Okay, that's helpful. And then lastly, you had said something about check on birth certificate, something about the vital records or something. What, can you remind me what you said? Yep, the Department of Vital Records is sort of a broad way of describing where you would find information about the process of registering a birth certificate, obtaining a copy of a birth certificate, whether you wanted your own, or you wanted a parent's, or you wanted a child's, or you wanted information about being added to a child's birth certificate. I don't think at this point anybody can just call up Vital Records, fill out a form, and get added to a birth certificate. I think it's a little more complicated than that, because we've had so many cases, so many questions over the years about about parentage, about same-sex parents, about same-sex adoptions, about making sure that parents who adopt children are at least a certain age gap. That's an interesting wrinkle in adoption law. Almost internationally, you have to be at least 10 years older than the person you seek to adopt. Things like that. Hi, Debbie. Thanks for joining us. If you have any questions anytime, just raise your hand and unmute yourself, and we'll fit that in, especially if you want me to know what kind of writing you tend to do. We've been talking about so far all about kids and all about custody and parenting time. If there's an interest, we can move on to more financial issues and that type of dilemma, which likewise varies across the country and is very different internationally. One of the fun things about reading a lot, and one of the fun things, I guess, about writing and researching a book, is you can take your ideas from other cultures. You don't have to necessarily be bound by an assumption that a judge will do exactly what he or she is supposed to do based on the letter of the law in his or her state. But all the laws regarding property division, spousal support, and child support vary from state to state. So if you're going to be talking real hard numbers, or trying to be talking about how this family is going to be working out their financial issues, you might want to know a little bit about the law in the state where they live, or you might want to be vague. And so let's talk about some umbrella ideas that can be easily portrayed without it being a mess. And so another common misconception to that earlier question at the top of the hour, I think there's a common misconception that the wife always gets the house. The reason that is out there, like so many other things, is that there's a nugget of truth to it. And here's the nugget of truth. The nugget of truth is that the wife always wants the house. And from a divorce lawyer's standpoint, it's, especially with what we've lived in since 2008, it's really stupid. I don't represent my friends as a matter of course. I try not to do it. I have and do represent my best friend, and she will tell anyone who will listen that the dumbest thing she ever did in her life was insist to me that she had to keep the house for the kids. Moms tend to make that connection emotionally to, I have to keep the house for the kids. And what the experts tell us, and there's so much reading you could do on the psychological impact of divorce on kids and what we believe to be true as opposed to what kids tell us later in life, is we tend to believe that kids shouldn't have to move. Well, it'd be nice if they didn't have to move. But there also are plenty of families that move kids all the time and kids turn out just fine. So keeping the house is an extraordinary financial risk. It's often an extraordinary financial burden because as a matter of math, when you take 100% of the family income and you split it in any way, it doesn't magically double. I'm a lawyer because I don't like to do a lot of math without a spreadsheet or a calculator, but I can do that math in my head, that 100% is 100% and I can't magically make it more. I wish I could. Because if I could magically make it more, then keeping the house might not be so stupid. It might not be such a burden. It might not be such a risk. So there is, of course, always the question, if you own the home, what's going to happen to the home? Is it going to get sold? Are the proceeds going to get rolled into somebody's new house? Are you going to both get the tiny apartments? Are you staying locally? Are you not staying locally? But that is one misconception, I think, which is that the moms always get the house. They're often the ones who want it, though. And so when you're negotiating a divorce, one of the things you want to know is, what does the other party want? I have a case right now where the mother doesn't care in the least about the primary family home in Wyckoff. She doesn't care. She cares that she get the shore house. So, and I know this, and that's in my back pocket. And when her husband insists that that he's going to give her something she wants, he's going to offer her the Wyckoff house, it's going to be great to be able to say, no thanks, don't need that, let's sell that, etc. So when we talk about property, generally we're talking about all of the property that people acquire during the marriage. I would think that prenuptial agreements and premarital assets could be an interesting item to try to address in the context of writing about a divorce or family law. When people come from different financial situations or have families before they get married, then they could certainly be in a situation where they have assets that they need to protect with an agreement before they get married. And that can impact what happens at the tail end of a divorce if a prenuptial agreement is done well. By way of a disclaimer, I really believe in prenuptial agreements. Not because I think that they are divorce planning. I think they are just an amazing tool for protecting children from prior relationships, for protecting other obligations you may think you're going to have as a grown-up, right? You may think you're going to have to help support your parents. You may have siblings who may need your financial assistance, things like that. But more importantly, on the day you're getting married, in theory, is the day you love and respect and trust your partner the most. And so if you set the rules for a divorce at a time when you hold each other in that high regard and things do go south, then the prenuptial agreement forces you back to that high level of respect and trust. You don't have to believe it, but you have to walk the walk because those are the rules of the game. That's the contract. I have a case right now that's going absolutely ridiculously haywire. My client came to me and said, she can have whatever assets she wants. I need, the business is premarital and I don't want to pay her any alimony. I said, great, show me your prenup. He's paying her alimony, paying her a lot of alimony because that's what the prenup says. And I can't get him out of it. We're not going to try because we wrote the rules and she relied on the rules too. And there's big downsides to her also. So prenuptial agreements vary a little bit state by state. New Jersey, for whatever it's worth, has some of the strangest prenuptial agreement laws, different from every other state in the union. So if you decide to go down that path with a prenuptial agreement in your plot line, move your characters to New York. It'll be easier. They don't live in New Jersey. That's all I ask. Or the agreement's not written under New Jersey law. Because that is going to screw you up. Those laws have likewise changed significantly over time, and it's worth thinking about when people actually got married and what they knew. The concept in a divorce when we talk about the finances, though, is this full financial disclosure. So when you talk about people hiding records and stealing records, another misconception in divorce real life, I don't know about anywhere else, is that you can get the upper hand in a divorce by getting all the documents. Again, that is something that may have been a little bit of an impediment to your spouse. If I emptied the family file cabinet and took the tax returns to my lawyer's office in 1990, that was significantly different than doing it today. Today, it's a punch of a button that my accountant sends out copies to everybody. I mean, it's not interesting anymore. There's nothing to that line anymore. There's nothing to that plot anymore to hold back the documents because everything's available electronically. And our court system, the divorce and family law system, does assume full financial disclosure, fair dealings. And so to the extent that anybody thinks that that's a grand, and a character or a real person thinks that that's a good way to get control over to get the upper hand, that's a misconception, a misnomer, and it's one that's easily fixed. Because once I know what you have in your marital life, in your life right now, I can figure out what it's worth. Some things are harder to value than others. Obviously, it's very hard to put price on anything that's unique, like art. It's very hard to put a price on anything that's ephemeral, like a career. And in some states, we do value professional degrees. For example, if any of you were getting divorced, we would want to look at this question of what's your earning capacity as a writer, and where does that get enhanced and where does that get repressed, depending on what else you do with your lives. Some things are harder to value than others, and that can be an interesting conversation for lawyers. I don't know if it's really interesting for the general public unless it's something fancy. I have a personal weakness for anyone who comes to me and says they've got classic cars. I love getting classic cars appraised. I think it's fascinating because they've been rebuilt and they've been changed, and if they're not in pristine condition, and if this one wheel spoke has been replaced, it kills the value. I think it's great. I digress. Once we know what everything is worth, we have to try to figure out how to divide it. And so generally, broadly speaking, throughout the country, we are usually trying to divide property equally. But money's fungible. Not all property is created equal. And sometimes somebody really wants the house, and sometimes something's not marital property for whatever reason. Now, take California and put it over there. Because California is community property, has a whole other set of rules for how you divide property and how you characterize what's in for divorce purposes and what's not. Basically, almost everything's in, but then they've got an exception list like a mile long, which is fascinating to divorce lawyers and nobody else. We divide property before we talk about alimony and child support because some property generates income and some doesn't, right? I mean, some income that you can use and some doesn't. But for the majority of our families, nothing that they have is going to change the fact that they're living off their paychecks, and maybe some gifting from outside of the marriage. Maybe there's some small dividends or something. Most people are living off their paychecks. So for most people, we're talking about dividing, when it comes to property, the house, the bank accounts, the vehicles, the household goods and furnishings. That's always a nightmare. The digital content that the family has now created, that's always a fun one. Retirement accounts. If they own a business, it's another whole discussion about how you're going to figure out what that business is worth. Life insurance, the stuff. And then we talking about the debts. Obviously, lots of families have more debts than they have income. Lots of families have gotten themselves into all kinds of problems with taxes and the IRS, and the federal government does not care about your divorce. If you've ever looked into the idea of filing for bankruptcy to get rid of tax debt, you know that's not happening. There may be some amnesty periods offered. And of course, right now, lots of people are taking advantage of different governmental programs. But for the most part, we have to figure out the awkward thing of dividing the debt. And that is often oppressive and very difficult for families to absorb. Because one of the things that happens at the end of a marriage that is dramatic, and it's always awkward for me as a divorce lawyer, is to explain, and I usually have to explain it a few times, I understand that that was her credit card and you didn't use that credit card and she just paid the minimum balance for 17 years and now it's a $45,000 balance. But when we look at a debt that exists at the time of a divorce, be it a tax debt, a consumer debt, or a mortgage or a student loan, anything like that, the question is, was there anything wrong in the way it was accumulated? It's kind of the flip side of what you might think. I don't have the obligation as the lawyer of the client who ran up the credit card debt to prove a darn thing. The other person has to look at that credit card debt and say, I didn't know all those weekends when she told me she was going to care for her mother. I didn't know that it was one day with her mother and one day dropping 20 grand a year in Atlantic City on debt. This concept that I'm getting at is dissipation of marital assets, wrongful use of marital assets, waste, marital waste. It's a terrible term, isn't it? But the idea is that one spouse deliberately used assets, wasted assets in a way that deprived the family of having access to it. Not so sure that applies to credit card debt because you haven't deprived the family of anything yet, but that's where the lawyers get in the weeds about it. But if you want to explore plot lines where you've got gambling issues, where you've got other addiction issues, where you've got flagrant spending, where you have somebody spending money on other people, John gave me a quick tutorial on the issues that prevent you as romance writers from getting into some of the nitty gritty of adultery and things like that. But even if you were going to, dangle the hint of it, the fact that someone went out to dinner with one person once is not the same as the idea that somebody was systematically paying for an apartment for somebody else or investing money in someone else's business or just gifting money out of the marriage to a third party. We would tend to call that dissipation. Now, there's this fine line between dissipation and entertainment. As a lawyer, and I would think as any of you writing a plot line, some of the things that people do with money that may seem wasteful to some of us is the most fun stuff. That's the fun stuff that's you want to write about sports gambling or just playing sports, golf, don't get me started. There's all kinds of things you can do with money that one spouse may not appreciate during the marriage, but if they knew about it, and if it was just some part of what they did for entertainment, that's not dissipation of assets. It could still be a fun thing to explore. It certainly is something we fight about a decent amount in the divorce context when we're getting down to dividing property. It's very difficult to get a court to get all worked up about it. They tend to want to leave people to their own devices, and that's where you can find that people are much more interested in sitting down and trying to find a way to say, okay, money is fungible. I know I'm never going to get you to admit that it was wrong to drop $20,000 in Atlantic City, but how about if you don't touch my $10,000 IRA and we call it quits? It's not necessarily fair, but if I get to keep something just to, if you give me something to shut me up, maybe we can work that through. We also need to talk about alimony and child support. And one thing that was not a misconception years ago, early on, when alimony first, one more thing, property division. There were very few laws, if any, about property division until the early 1970s. So if your time period is taking you back any further than that, you're going to want to look a little bit more deeply into where they were and what was going on. In New Jersey, we did not have a law about dividing property until 1971. John, was that a hand? Okay.
I do have a question.
Sure.
Just before we move on for property division, say I have a character who inherited a lot of money from family or whatever, whether or money or artwork, antiques, whatever. How does that fall into a divorce?
Sure. So premarital property or non-marital property or an inherited property, we should be able to keep separate. This is just like my afternoon yesterday. I spent the entire afternoon on the phone coaching someone through the fact that her mother had just passed away. And she and her 3 siblings are going to be inheriting bank accounts and a house to sell, etc. So there are a few things that are fairly stable laws across the board in the United States at least, which is that if you inherit or are given money by someone outside, not your spouse, during your marriage, it's your property as long as you keep it separate. And that sounds really simple. That's easy. I'm going to take that money and I'm going to put it in a bank account and I'm going to keep it separate. Yeah, well, that bank account, because you're a smart person, is going to generate some interest. And you're going to claim that interest on your tax returns. That $13 a year, you're going to claim that on your joint tax returns, right? And how are you going to pay that taxes on that $13 a year? You're going to write a check from the joint account. And then you have not kept it separate. It's silly little things like that that could be fun for writers to dig into. But if I said, what I said to this woman was, listen, you're going to have $1 million or whatever it's going to be, put in an investment account. At the end of every tax year, by all means, file joint tax returns. And I often write that into my prenuptial agreements, that filing joint tax returns does not itself make non-marital or premarital property into joint property. But then you just have to make sure that you pull money out of that inherited bank account to pay your own taxes. So there's easy fixes as long as people think. But I expect that some of your greatest plotline successes come from the fact that people don't think, and that makes it realistic. We don't always think through the consequences of what we start out to do. So that's that. The other thing that's kind of quirky, that's interesting to know, is there's this idea when you're married. Love your question about misconceptions. That was a really good starting point, a really good trigger for me. One big misconception is that when my lovely husband gives me a present for Valentine's Day, then it's mine. And that is completely wrong. If I get a present from my spouse, or I give a present to my spouse for his birthday, Valentine's Day, Christmas, anything like that, when we're married, the assumption is that I did that using the money that I earned during the marriage, or that he earned during the marriage. Therefore, all I've done is create one asset out of another, one joint asset out of another. Because you probably have all met people like this who function on this operation that, yeah, we're married, but we have completely separate financial lives. We have separate bank accounts. We file separate tax returns. We do a true up at the end of every month. I had these friends who had like lists on the refrigerator, and that's what made them happy. The end of every month, they did an even Steven kind of thing. But all they were doing was making themselves comfortable, which is fine. But had they gotten divorced, every dime they had made during the marriage is joint property. And therefore, any savings, whether it be retirement savings or bank accounts or anything like that, is also joint property. And that's where a prenuptial agreement can draw different lines and separate things differently. And a lot of people are more comfortable doing that, especially people, like I said, who have other support obligations, children from prior marriages, people who are getting married later in life, whether they have other obligations or not. Some of them really feel strongly that, yes, we want to be married for certain reasons, but what I'm going to earn is mine, and I'm responsible for my income and my debts. And same for you. And we're going to have a joint bank account, and we're going to pool for specific joint expenses. And they're allowed to do that if they write it down. But if you don't do that and you get to the end of a divorce, I love, it's always the same. Somebody comes in and starts talking about it's ours, it's our house, it's our kids, it's our bank accounts, it's our cars, and then it's my 401k. It's not your retirement account. It may be in your name, but it's joint property to the extent that it was earned during the marriage. So that's the kind of thing that I can't fully defend or separate. Debbie, mute. Take yourself off.
Okay, thanks. My question is, if you have, because a lot of people are getting married later in life, so whether it's a second marriage or a first time, finding true love, whatever, if they have a 401k or an IRA or some retirement fund prior to entering that marriage, what assets are there, would that then become joint once they enter the marriage? Or would that be that would be their IRA, but then anything accumulated from the time of the marriage forward would be the joint asset, something like that, right?
Yeah, no, that's a really smart question. It's a question that makes a lot of sense in the context of what Michael was just asking. So 401ks, let's talk about them particularly, because it's not like you can just go open a new 401k account. You work for the same employer. I'm working with a guy right now who's at Bloomberg. He's been at Bloomberg for 20 some odd years. He's been married for 6 years. How are we going to figure out what was premarital and what was non-marital? A big company like that kept their financial plan relatively consistent and didn't switch around between Fidelity, Vanguard, didn't skip around the investment houses, can give me statements, and I can figure out what the balance was as of the date of the marriage. And I can protect that balance plus market changes and losses to the date of a divorce. Oddly, for all that I just said about whatever we have is ours, and we didn't even talk about commingling money yet so much, we are very respectful of the fact that with 401ks in particular, it's impossible. The ERISA, the federal law that governs the creation of those plans and permits us to tax defer on those plans, does not permit you to say, I got married over the weekend, can I have a whole new 401k account? You just can't do that. So we are respectful of the fact that we have to back into the question of what's the premarital component, and we do set it aside. So that's one thing. IRAs are trickier, and I think you'd find some fights about that. I mean, it seems to me that if I have an IRA when I get married and I don't do anything with it, if it just sits and grows, that's not a problem. The problem is when you say, oh, I'm going to also make the maximum contribution every year to the IRA. Then you've mixed premarital and marital money, And I personally try to be consistent throughout my professional life. I tell every client and every lawyer the same thing. If we can back it out, we should. If we can guesstimate fairly what the premarital component is, we should, because it's a retirement asset. But on the other hand, if someone is smart enough to ask me when they're getting married or we're doing a prenuptial agreement, what should I do? I'm like, that IRA can sit and it can grow and you can do whatever you want with it. But if you want to make IRA contributions to continuously, just open a new IRA. It's not that hard. The smartest thing someone with wealth can do is the week they get married, stop using one set of accounts and start using another set of accounts. But it's not strictly necessary, and most people aren't wealthy enough that it's going to make a huge difference. So let's move on then, talking about alimony and child support. And I am mindful of the time, and I know you all have been on a committee meeting before I even jumped on the call, so I don't want to keep you any longer than you wish to be blathered at about family law. But alimony and child support are drastically different all throughout the country. They're drastically different within different states. I don't know this for a fact because I don't practice there, but I am told that in some of the Midwestern states, they calculate child support differently county by county, which could make for some really interesting times depending on whether, because you can't move across state lines, right? But you can move to a county where you get more child support. Just a thought, big state, I don't know. So most states in the United States at this point have moved to some type of a formula-based system for alimony, which is spousal maintenance, which is premised upon the creation of a financial imbalance during the marriage that does not enable both spouses to have a fair standard of living after the fact. And I'm grossly oversimplifying this. New Jersey does not have a formula. Most states do, New Jersey does not. New York has a formula that sets a minimum. So one of the things that we find is that when you, as I say, when you split 100% of the income, it doesn't magically double. And when there's less to go around to support two households, it's hard on everybody. And what we're trying to do with those formulas, or trying to do with a factually based alimony award, is to figure out what is the potential for cutting expenses, for increasing income, and trying to maintain the status quo in the short term or the long term if it's possible. It's just rarely possible in the long term for us to increase expenses without increasing income. Interesting question, and perhaps a misconception, and I may be in the minority of this among lawyers, but a question I get a lot is from someone who's not working, and that's not even gender-based anymore. If they're the ones staying home with the kids, or they're the ones being the logistically and otherwise supporting spouse at home, is should I go get a job? Lots of lawyers will told me I should not go get a job right now because I'll get more alimony. Well, unless there's a lot of wealth, there's not enough money in your alimony package to make it worth you staying home, not earning money one more day, if that's what you wish to do. I happen to encourage people to find a way to go out and make money, because you see it all the time in fiction and nonfiction, that somebody is in a difficult situation of trying to figure out how to put food on the table, how to keep the house, because there's just not enough money coming in from support. Or we're hearing this now, I'm sure there are going to be real stories that we're all going to hear in the next 6 months, that people couldn't make it through COVID. Their income stream disappeared, or was severely reduced, or they got sick, or they had to care for sick people. It's going to be a problem. And we know that families' financial stability is more than just the luxuries. It's about the bare necessities, and it's about their emotional well-being as well. Child support is supposed to be for the kids. Spousal support is supposed to be for the parent. And we do want to try to encourage people to the point where if they feel like they need to get retrained or get more information about how they can earn money for themselves, that can be part of a divorce or a family law obligation as well. A judge can order one spouse to help pay for the re-education and the integration into the workforce of the other. I tell my clients it's a great investment. The minute I get a whisper that the spouse who makes less wants to go do something to get trained to earn more, assuming that I'm looking at a long-term alimony obligation, and I'll get back to that, I think that's like the best idea in the world. Yes, let's pay him to finish that master's degree. Absolutely, let's find money in the marital estate for you to finish your education, for you to go get certified doing something fancy or something simple. because what we're trying to do is to improve the marital family, the situation for the family overall. Alimony terms. Hi, Dawn. What's up?
I just wanted to ask, based on the economics you were talking about, you may see people who cannot afford to move apart. And I was wondering if you have been drawing up contracts for separating while living together, like the rules of engagement for that.
We can actually do a full divorce and you can live under one roof. There is no requirement in any of our Hudson Valley states that you actually live apart to be divorced. All 3 states are no-fault states. Irreconcilable differences are fair game, and you can get divorced simply by saying that the marriage is irretrievably broken, that those differences have lasted for a period of at least 6 months, and there's no reasonable prospect of reconciliation, and nobody cares where you live. So I have, in rare situations, and it's not ideal, had families living all under the same roof for a period of time following a divorce, usually while they wait to sell a house and liquidate the proceeds. In one case in particular, we did it, sort of the family drove this decision, not the lawyers. They basically said, no, we want to get the divorce done so that when the daughter turns 18 and goes off to college, everybody just moves on. A little strange. That's what they wanted, so we did it. I'm actually not clear when they told her they had gotten divorced. I am getting a low battery signal too, so I'm going to move my computer, but I'll keep talking.
So would there be rules about dating and things like that involved? Because you would if you're living separate lives together?
So the rules on dating are interesting. There is, of course, this question about adultery. And is it something that our judges care about? Is it something that any of our psychological experts care about? Kind of what is the idea behind whether it makes sense to be involved in a relationship when you've got kids? And there's no straight rules on this. There's no law on this. Adultery, this is a tough one to discuss with the client who comes in who's been scorned. Because what I unfortunately have to tell almost everybody is that our judges don't care. Most of our judges don't care a whole lot about adultery unless it is incredibly flagrant or unless it has impacted the children. So I'm going to steal a story from one of my friends out of Connecticut, whose husband brought home one day this beautiful painting. He's going to paint a beautiful painting of a full-size, over-the-fireplace painting of a nude woman, and kind of in the abstract, but absolutely gorgeous. He had seen this painting. He had to have this painting. And they hung it up over the fireplace. And you're all laughing because you know what happens because you read the book. It turns out it's a painting of his girlfriend that he had commissioned. And he hung it up in his living room for his family to see. My girlfriend was representing the wife, and she took great delight in making this a key point in his insuitability as a custodian, because his judgment was so poor, because his cruelty was so great, and because his use of funds was so ridiculous. So not to say that it never matters, but if I went into a court and storming in, I should get extra alimony because he cheated. No, that gets me nowhere. In fact, in a lot of states, there's specific law that says that you don't get additional spousal support because of infidelity, that it has to be based on economic need. Not to say that there may not be a way to tie it all in. But I tell my clients all the time, and I have a blog post up called Why Adultery Matters. It's kind of an old one. You'd have to scroll back. But the idea is, to me, that it matters if it impacts your children. If you are making the choice as a parent to spend time with someone else instead of your kids, if you're skipping baseball games, if you are not making it to parent-teacher conferences, or you're just not home at night because you've made the decision to be with someone else, I'm going to, as a lawyer, have a problem with you as my client. We're going to fix that if I get wind of it. And certainly if it is happening on the other side, I'm going to make a stink about it. Our courts have very limited ability to order that the paramour or the boyfriend, girlfriend, or whatever you want to call them, stay away from the children once a divorce is final, but they have very broad authority to do it while the divorce is happening. So that's a good thing for me to keep in mind always, is that I can only control people for so far, and people make interesting choices, and my judges have the same kinds of limitations.
How long do the terms of alimony last?
Depends.
Definite?
Yeah, so it depends where you are, and it depends what your situation is. And it is completely inconsistent nationwide. The most extreme example I've heard of is in Texas. No matter how long you've been married and no matter how much money there is or isn't, you are maxed out at 3 years of alimony. It is a shocking concept if you think about being the spouse who got left behind when someone climbed the corporate ladder. In New Jersey, we have no limits on a term or a payout term of alimony if you've been married at least 20 years. But do the math. If you've been married at least 20 years, you're probably at least 40 by now, probably older, and you're probably heading into retirement. And we have some pretty generous rules about ending alimony on retirement. So it matters a lot where you are. We do run that all state by state. Somebody else had a question before we jumped onto alimony. Debbie.
Yeah, I was just talking about infidelity again. I know because it's a no-fault state and irreconcilable differences. Do people still try to use, a cheating spouse as a grounds for divorce, or do you try to go with the, irreconcilable differences over that? Because I know one will damage the other's reputation. So could that be a good plot device to? I mean, I don't know the laws now. My ex-husband was an attorney. Just saying. So.
No, the law is definitely out there. You can still file for divorce on the grounds of adultery. My question is always, what does that mean and what state are you in? So because sometimes I'm in cases where we're trying to decide where to file for divorce because people own homes in both places and you kind of can maneuver it one way or the other. If you're going to file for divorce, you usually have to name who it's with. Sometimes you may not know. And sometimes that may just be something that your client doesn't want to do. My client doesn't want to do. It's terrible, but do I really want to drag him or her into it? That's only going to make this worse. It's not going to make this better. You can also file for adultery, and sometimes you have to do this if it's been a serial situation where you basically say it's been in numerous places with numerous people presently unknown to me. I've got one sitting on my desk. We were going to file in May. I don't think we're going to now. That says something along the lines of with numerous paid companions, the true identity of whom is unknown to me. She knows he's been paying prostitutes. We don't know who they really are. We've got actually some vivid proof of it. It's kind of awful. So you can do it. It's out there. The question is why. And if you don't have small children, that's one reason. If you have small children and it has impacted your custody situation and you are worried that you have to defend your right to primary custody of children, that's one reason to do it because it gives you a platform to bring it out. The other reason to do it might be is if you've got that whole question of where did the money go, and if you think it went out to somebody else. There's some legal technicalities. Just one quick thing, Tara, because one of the things that one reason I sometimes don't file for adultery is because there's a strange wrinkle in the law in New Jersey anyway, and I actually don't know about New York or Connecticut. If once I file on the grounds of adultery, I'm not allowed to take the other party's deposition about the adultery. So for example, it's weird. If I file on irreconcilable differences, I'm not allowed to get them under oath and say, well, what do you mean by irreconcilable differences? You said it's irreconcilable differences. What does that mean to you? Why is it irreconcilable? What are the differences? And so if I file on adultery, I'm then prevented from taking that deposition. That may not work for me. Tara.
I was just wondering, typically, how long does it take to settle? I mean, I've heard an extreme case, like where started when someone was pregnant and all the way till they graduated college, the children in and out of court. I mean, I can't say is that typical, or, how long does it usually take to?
So we're talking straight about divorce. So when you file for divorce, our judges tend to assume that they want your case to finish within a year. That is a joke at this point in time. But aside from that, it goes to judicial resources and what the complexities are of the issues. I have certainly had cases that through no fault of the parties, well, maybe it's their fault a little, but you could certainly go 2 years. That's not a huge shock. 3 years if you've got a complex business issue or strange issues involving the children. But certainly after the 1 year mark, my experience has been, and my friends' experiences have been, that you start getting pressure from the court. So you start getting asked, why aren't you going to mediation? They start setting more and more court conferences, so your clients get inconvenienced. They have to come to court, they have to pay you. So after a year, you start getting attention from the courts. But the other thing that happens, and this goes to alimony, child support, and custody, and maybe property, is that after you settle a divorce or get a judicial judgment of divorce, you can still litigate ad infinitum about what it all means and who did it right and who did it wrong and who owes what to whom. So you can argue about the property division. You don't get to come back and redo it. Once you settle property, it's done. That's worth knowing. That once you can always agree to modify it, but you can't force that. But you can, alimony is always modifiable unless you have bargained for it to be non-modifiable. Child support's always modifiable. New Jersey and Connecticut have obligations. Parents contribute to college costs, so that's something else to litigate over. New York does not. New York emancipates children at age 21. The day a child turns 21 in New York, the child support stops automatically by statute. So if you are the parent paying child support on your child's 21st birthday, you are entitled to stop that unless you have written and signed an agreement that says something else. My husband's a college professor in New York. His students do not like hearing that.
Yeah, but they could still be in college at 21.
Correct.
They may still have to pay for education.
Not in New York, unless they have signed a deal saying that they will pay for college, they do not have to.
So it could keep going on.
It can. It's not insane to say that you can litigate for years. And I have a new client, God bless her. She lives out of state. Husband lives in New Jersey. He's been paying her alimony for 20 some odd years, and she called me and hired me over the phone, and the children, and it's very clear to me she has 2 kids living with her. Okay, I'm trying to do the math. Like, you've been divorced 20 years, you have 2 kids still living with you. Like, were you I didn't know. I didn't want to ask. Were you pregnant when you got divorced? Like, what's going on? No. The children are 30 and 35 years old. He's been paying alimony all this time. He's 70 years old, and he wants to end alimony, and she's a little upset about that. And I understand why she's upset. But here's a situation where she's pretty much been litigating for 20 some odd years, and not because anybody did anything wrong. I mean, they had their glitches along the way, but we've gotten to the expected terminus of probably what he's going to have to pay in alimony, depending on a lot of things. I mean, obviously I'm going to fight to continue it at some level, but here we are. She's been divorced for 20 some odd years, and her kids are in their 30s, and yeah, she's going to wind up back in family court. I know you all have been at this for a while. If anybody has any interest, I could certainly hit the high points on mediation, arbitration, collaborative law, or we could do it at another time, or you could reach out to me individually, whatever's best for you.
I don't know. I think that I would love to have you come back in a few months and talk to us about COVID-inspired cases.
Yeah, I think I'd have some questions about that myself.
Yeah.
I think we all do. I'm doing a presentation next week for the Bergen County Professional Women's Network on that issue, about where some of us see families heading, what we are worried about. And certainly I will tell you, in the first couple of weeks were okay. We were primarily dealing with social distancing and who was going to respect what boundaries, and were we going to modify custody schedules, and everybody was, we're all in this together. And the wheels are coming off. And the calls are coming in. It's going to be interesting. I definitely have one where the mom has not been social distancing, and we are going to modify the custody schedule on an emergency basis. I have another one where the person paying alimony is a performer in New York City, and you can't argue that she should have been working. You can't. So yeah. Definitely we can reschedule that at whatever time works for your group. I'd be happy to come back.
Yeah, we'd love to have you. This has been really, really great. I appreciate all the time, all the preparation you put in, the fact that you came to me and asked what would be appropriate to speak about. It really has been a great talk.
Do you have definitely target to COVID or not?
Yeah. Are you okay if I put this on our website? Because I've taped most of it. Yeah. Okay. I just wanted to make sure that you were good with that.
I agree.
Does anybody have any final questions?
I've got lots of questions.
I hope you all have plans to be out.
I found it fascinating when I jumped in. Sorry I was late, guys. I had to work today. But Yeah, no, I found it fascinating what you said. And my ex-husband is an attorney in New York, and going through a divorce with an attorney is like a whole different, so much fun. That's all.
Yeah, it's not the job itself, it's the personality that it tends to bring.
Yeah.
But there certainly
Pitfalls.
is, you know,
Pitfalls.
one of the things that we've all been seeing lately, of course, is, you know, you shouldn't use a Google search for anything that a professional should give you advice about. And we are all falling prey to that now that we're home more and more. So I think that we're all going to see more of that. And whatever, if you all have lives and jobs on top of the writing that you do, I think we're all going to see more and more people being critical of us for everything we do, because they already researched this.
Yeah.
Sure you do.
Well, thank you again.
Thank
Really
you.
appreciate it. We will
Welcome. I
definitely
just
have
put
you
my
come back.
email address in the chat.
I saw that. Thank you.
Great, thank
Thanks.
you. And everybody
you.
have a great month, and I will see you
You
shortly.
too.
All right, take
Take
care.
care.
Thank
Thanks
you,
again.
Amanda.
Bye.
Yeah.
Bye.